Okay, the question I always get on intermittent leave is the notice requirement. Can we get a doctor's note each time they use intermittent leave, right? They claim they have migraines or depression, and they call in sick randomly, and we want a doctor's note each time they call in, right? Did any of you have ever had that question asked? And the answer is no, you can't require that they get a doctor's note each time. You have to follow the FMLA rules. Now, you may be able to require it if there's a paid leave substitution. So if they are using substitution of paid leave, and your paid leave program requires that to receive the paid leave, that they follow some procedural requirements, then with respect to the paid leave program, you can make those requirements as long as you do so across the board, not just the people on FMLA. And if they don't choose to follow those requirements, then they don't get the paid leave, but they still get the FMLA leave. And if you're going to have those requirements, you must notify them ahead of time of exactly that in writing, that the requirements are in connection with your receipt of the paid leave benefits, that if you choose not to comply with the requirements, you will not be eligible for the paid leave benefits, but you will still be eligible for the FMLA leave. So just know that if you plan on requiring that they bring a note in every certain number of absences from a doctor, and that's in connection with the paid leave program, that your form better be very clear about that requirement, and better also say that they're still eligible for FMLA if they don't comply.
So what do you do when you have the employee who has migraines who calls in and says they have a migraine and then is seen at the bar that night, or bowling, or shopping at Walmart, or out by other staff?
Okay, so what you're really asking about relates to a couple of issues. One is the initial certification, and two is recertification, and three is potential fraud. So the first step to evaluating your question is really relating to what you get when you do your initial certification, how thorough you are in the process, and whether you consider that fraud may be going on, so you do exercise some of your options under the FMLA for getting a second and third medical opinion. The first step that I would recommend is it's important to make sure that you have a certification that is complete. Has the employee doing the certification that's really got the information you need to know to justify that this is correctly an FMLA, intermittent or reduced schedule leave. I had a case once where an employer, if you ever go to Office Depot and you buy those little invoice receipt books that you can perforate out, it's got the little piece, and literally that was the FMLA note they took from the employee. And the employee, I could swear, the employee did it himself, went to the Staples and filled it out himself and wrote $5 as if he made a copay and turned that into the employer, and they put that in his medical file as acceptance that he needed FMLA leave. So, the answer is that's at one extreme. The other extreme is most employers have a form, but there's language in it they can't read. I've had conversations with HR people, and what is that word? They don't even know what the word is on the form. Okay, well, if you can't read a word, how can you know it's valid? How can you comply with it? So it's important to make sure that it's complete. If it's incomplete, there's a process for you to follow up. If an incomplete, a certification that's incomplete doesn't justify leave of absence. So you may be able to potentially deny the leave by following this process. The first thing is if it's incomplete, you have to go back to the employee in writing and let the employee know why it's incomplete or what is insufficient. The FMLA regs talk about two things, incomplete and insufficient. Incomplete is a required piece of information, it's just not there. Insufficient is it's non-responsive or evasive, okay? And if you have something that's missing, or it's not responsive, or it's evasive, you have a right to go back to the employee and say to the employee, this is incomplete or it's insufficient, we need additional information. If the employee has done that and gotten you the information, and your first step really needs to be with the employee. Once that piece is done and you've gotten a response from the employee, if you still have questions about the certification, you can do authentication and clarification. Do any of you do authentication? How many of you do authentication? Authentication is a great idea. Authentication means you're the doctor and I fax you a copy of the form and I say, is this authorized by you or your office? And sometimes they're not actually authorized by the doctor, they're made up. Gee whiz, employees making things up. I had one case where in exchange for Starbucks, the employee had a friend who worked as a medical assistant for a doctor, and in exchange for bringing her a nice $4.25 latte, the friend wrote out medical certifications. And we're able to discover these things if you actually do things like authentication. So you should really consider that. You have a right to do it. You do not need the employee's permission or consent in writing to authenticate. Authentication can only be done under the regulations by a certain number of people. It can never be the employee's direct supervisor. It can only be an HR lead official or HR person or a management official. Don't let a management official ever do it, they'll screw it up. It should be an HR official. If it's your employee and you're in HR, then it should be another HR official, because you can never authenticate on behalf of your own employee. Of course, you can't ask for more information. The purpose of authentication is to just find out if this is a valid medical certification that you signed or it's been authorized by your office. Now, the next thing you can do is you can also seek clarification from the doctor. And again, technically, you don't need permission from the employee to seek clarification. However, the doctor will need permission from the employee to share information, because authentication doesn't result in the disclosure of privacy information that's protected by HIPAA. But clarification does, because you're asking the doctor to clarify what he or she meant by some provision in the release. And so that involves a discussion of a medical issue. So the doctor can only do that clarification if their patient has consented, signed a HIPAA release to be able to provide that information. At least many doctors will not disclose that without that. The regulations say that if an employee does not, if you have the right to clarify something, and you're making a reasonable request to clarify something, and an employee does not cooperate by giving your doctor that permission, then you may deny the leave. So there's real options for you.